welcome back to a lecture on children matters. Today, last time we talked about the definition of a child, of minors. We talked about the best interest principle, other general principles, and also the factors you will consider, the court will consider in making a order in relation to a children's custody and education. So finally today, we will be talking about the orders that the court can make in relation to custody and upbringing of children. And then we will also be talking about relocation. It is something that you need to consider when you want to move permanently to another jurisdiction with your children. And in the end, I will talk to you briefly about wardship, just to complete the picture. Now, wardship is for the situations when the thing you want to ask is not covered by the matrimonial proceedings and property ordinance or the guardianship of minors ordinance. So you would have to resort to wardship in certain situations. And surrogacy is one of the examples where you would have to consider wardship. And one thing you should be clear about is that when we talk about a children order, we are strictly concerned with the custody, upbringing and education matter of children. It does not cover maintenance. Children maintenance is part of the finance. And that part will be dealt with after we have a children order, because we need to know the children arrangement first. We need to know how the parents will share their parental responsibilities in looking after the children before we can decide who should bear the financial responsibilities and how much. Okay, so that part we will deal with in ancillary relief, together with ancillary relief. In the divorce, the provision governing children order is section 19 of the MPPO. Okay, it's very straightforward, so I wouldn't read it. But there are a few points you should note. The statute provides for an order for the custody and education, which I have underlined here. Custody is interpreted in a broad sense, so it can include custody itself, can control and access, and other matters. For education, sometimes when the parents cannot agree on education, such as which school the children should go to, then the judge can decide on this matter. This is called a schooling application. And in my understanding, schooling is part of the consideration of custody in relation to a child. The second point is child of the family. Okay? So if you remember, child of the family means a child of both parties to a marriage or any other child who has been treated by both parties as a child of the family. So remember, in last time I raised a scenario where you have the husband and the wife. The wife has a child with another man, the biological father. The father can apply to have custodial rights for the custody of the child under subsection D in GMO, right? And by virtue of section 19, it seems that if the husband, even though he's not the biological father of the child, if he has treated the child as a child of the family, he can also ask for custody. But the problem is, as I raised it last time, there will be 3 parents with custodial rights in this situation. Okay, this is a conflict that I haven't quite resolved myself. In reality, it wouldn't happen, because normally the biological father wouldn't care about the child. So at best you would have the mother, who's the wife, and then the husband. At best. The husband probably doesn't care either. So it's very unlikely in reality, but I'm just flagging it out for you to consider. And if you have resolved this legal issue, please let me know, because I really don't know. Okay? The third thing is that the child has to be under the age of 18. For this, you would have to read subsection 1 of section 19 together with subsection 7, which is in your next slide here. Okay, and you should have your slide in front of you. Once the child has reached majority, on the day he turns 18 years old, he is out of the hands of the court and his parents. So in other words, in a divorce, if there are children involved, but they are all over 18, then you don't have to deal with children matters at all, and you can't. But just to let you know in advance, in this slide you will see that the 18-year-old bar is different for finance. The court does have the power to make children maintenance orders for children who are over 18 years old if they're still at school or receiving some form of training. And we will cover that again in ancillary relief. But just to flag out the difference between custody and maintenance for children. Okay. The court, as you will see in A and B here, the court can make a custody order anytime during the divorce proceedings. So it can be an interim order at any stage, and of course, in the end, there will be a final order. And even after the conclusion of the divorce, you can go back to the court to vary the custody arrangement before the child attains 18. Okay, and the last bit also provides that the court can consider directing the proceedings to be taken for making the child a ward of the court. That means, in an appropriate case, if, for instance, the court discovers a surrogacy arrangement, it would direct the children proceedings to be transferred to the High Court for wardship, instead of making an order under MPPO in the family court level. Okay? So these are all the information that Section 19 tells you about the custody of children. Okay, and this slide, I just covered it. I have this slide here for your reference. Apart from custody and education orders, as in subsection 1, you also have other subsections in section 19. The court also has the power to make a declaration that either party to the marriage in question is unfit to have the custody of the children of the family. Okay. And in 4, with such a declaration saying that the parents are unfit, upon the death of such a parent, the other parent is not entitled to custody or guardianship of the child either. 5, the court has the power to make an order in respect of the custody and education of the child or family from time to time. So this is to a furtherance of subsection 1, because subsection 1 says that there can be an order in the divorce proceedings, and here subsection 5 is even more specific. It makes it very clear that you can have an interim order at different stages during the divorce proceedings, and you don't necessarily have to wait until the trial. So procedurally, in a children's appointment hearing, you can ask for an interim order. And if you go to a CDR and you fail to settle on children matters, you can also ask for an interim order, because there must be some sort of arrangement to look after the interest of a child at any point of time before he reaches 18. But apart from this, apart from the usual court proceedings, if there's urgency, you can also issue a separate summons on children and ask for interim order. For instance, you might, in an urgent situation, you might ask for the return of children. So in that case, if you don't have a children's appointment coming up, then you need to issue a separate application to fight for an earlier date to hear the return of the children, maybe next week. And before the summons is eventually decided at the direction hearings at the summons, you can have an interim order. Okay. So you can have a summons for an interim order because it hasn't reached the stage of the trial. The final order is given at the trial or reached by settlement at a CDR. Before that, you can have, well, you can either rely on the usual court procedure for an interim order, or if it's really urgent, then you can issue a summons separately for an interim order. And before that summons is decided, you can have an interim order. Okay. Subsection 6. The power to discharge or vary an order made under Section 19 to suspend any provision temporarily and to revive the operation. So this is about variation. The general principle is that there must be some changes in the circumstances that warrant the change in children arrangements. So during the proceedings, when you ask for an interim order, you can ask to vary the interim order. At the beginning, it's very typical that one party would have more time with the children. That's an interim arrangement. And then after a few months, you can ask to vary that. Or after you have had a final order on custody matters, you can go back to court to vary upon changes of circumstances. But usually, in order to succeed, in order to have those facts of changes of circumstances, you will wait for maybe 2 to 3 years when the children have grown and moved on to the next stage of development. That is more likely. Okay? So Section 19 deals with children in the course of a divorce. But when there isn't a divorce, or where there isn't a marriage to begin with, MPPO is not applicable, and you refer to the GMO, the Guardianship of Minors Ordinance. For custody, the provision is in subsection 1. Of section 10, GMO. So it says there, if you want a order on custody or access on a minor is a person under 18, then you can do so by way of an application of either of the parents, the biological parents, or the Director of Social Welfare. So remember last time, if the parents are not married, then only the mother has the right. So the father has to firstly apply under subsection D, and then simultaneously he has to make an application for custody under section 10. So in a divorce, it's Section 19 MPPO. In a non-divorce situation, it's Section 10, subsection 1 of the GMO. Okay? Should be very straightforward. There are, you would have heard me say enough of the important terms. The concepts, there are three mainly. You would have custody, care and control, and access. The first is custody. In Chinese, it is called 管养权. It is not 抚养权. Okay? You should know this after you have studied family law. 抚养权 is not a proper legal term. It is used by the public. It should be 管養. 管教個管，供養個養. Okay. I have included this Court of Appeal judgment of PD and KWW by Mr. Justice Hartman for you. It contains a discussion of the meaning of custody, sole and joint custody, as well as care and control. It is said in paragraph 31 that the decisions to be made by a custodial parent are those of real consequence in safeguarding and promoting the child's health, development, and general welfare. It is a relatively broad and abstract concept. They include decisions as to whether or not the child should undergo a medical operation, what religion the child should adhere to, and what school the child should attend, what extracurricular activities the child should pursue, be it learning a musical instrument or being coached in a sport. A parent vested with custody has the responsibility of acting as the child's legal representative. Okay, so custody comprises the bundle of rights that parents have in relation to their children. It implies the right to make all important decisions affecting the child, such as education, schooling, and medical treatment. And these are the three typical children matters that go with the right of custody. And apart from that, it says here it can include ECA, extracurricular activities. It can also include the right to remove a child permanently from the jurisdiction, so relocation. Okay. These rights are really broad, abstract, and it's not something that it does not the decisions it concerns are not the ones you have to make every day. Okay, it's decisions on schooling, so you have to make that decision maybe 2 or 3 times in a child's life. Decision on medical, you probably don't have to make that decisions at all if there aren't any medical issues with the child. And religion, one decision. Okay. With custody, you can have sole custody or joint custody. Traditionally, a custody order is usually with sole custody. But in recent years, we are seeing more and more joint custody when both parents are capable of making rational, sound decisions for the children, and they can work together and make those decisions jointly for the sake of the children. Okay. So for sole custody, it says in paragraph 40 that the giving of sole custody to one parent does no more than recognize that in the circumstances of the breakdown of the marriage, the best interests of the child are secured by giving to that parent the authority, if necessary, to make a final decision concerning matters of consequence in the upbringing of the child, but only after the other parent's views have been given full and rational consideration. So in summary, an order of sole custody does no more than to add a qualification to the otherwise joint endeavor of both parents in raising their child, that qualification being that the final decision will rest with one parent. So the point is, when one parent has custody, that person has the right to make the final decision. But even if you have sole custody, you have the duty to inform and to consult the other parent. You have to have the other parent's view considered before you make a decision on custody matters. And if that other parent doesn't like the decision that you make, he should bring the matter to the court for the court to decide. Okay. As to joint custody, just bear with me, is a little bit long. Today, although there has been no change in our law, similar to many other common law jurisdictions, orders for joint custody are in no way exceptional. This is because it is accepted that in principle, such orders are in the interest of children. Joint custody is actually trendy. Right? It should be, in my view, it should be the norm. And it's definitely not the exception. In all but the most exceptional circumstances, the effect of divorce on the children of the marriage, especially children of tender years, is deeply felt. In all but the most exceptional circumstances, such children desire they should continue to be protected and guided by both parents. Okay? That's why we are moving towards more joint custody instead of sole custody. So in the result, in the best interest of the child, the fact that relationships between the parents are strained is not of itself a reason to refuse to make a joint order of custody. Nor is the fact that the parent to be given care and control does not agree. An order of custody looks to the future. They will govern a limited area of exchange between the parents, albeit one of the greatest importance. Okay? So the issue for the judge to decide whether to give a sole or joint custody order is that whether it is reasonably anticipated that the parents will be able to agree on questions of importance that would determine the upbringing of their child. Both recognizing this process of cooperation is in the best interest of the child. Sorry, there's one more slide. In determining the issue, the judge is entitled to proceed on the presumption, this is a rationale, that competent, loving parents possessed of sufficient objectivity to be able to make rational decisions in the interest of the child will be able to cooperate with each other, with each concerning matters of importance in the upbringing of the child. At all times, of course, the welfare of the child remains the first and paramount consideration. It is recognized that there may be occasions where the ability of the parents to reach any rational accord in respect of important matters concerning the upbringing of the child is so deeply undermined that to compel attempts at cooperation will not protect the interest of the child, but only leave the child more vulnerable. So the key takeaway points are, basically, we should assume that both parents are capable of making all these important decisions for the children. But if one of them is not able to do so, then we can't, in order to promote co-parenting, force them to have joint custody, because it would adversely impact, it would leave an adverse impact on the welfare of the child. But then, if both parents can make those rational decisions and they can do so together, then the court is very likely to make joint custody orders. Okay, so forget about what you have watched in TVB dramas. Words like you want to fight for the children, it doesn't exist in reality. It's not encouraged by the court. Okay, so you should do away with that mindset of fighting for children. Because it really doesn't matter. Even if you have sole custody, you still have to consult the other parent. Your decision, even if you have sole custody, does not usurp the power of the court to make a different decision on the same matter for the sake of the interest of the child. Okay. In reality, at least my clients, in most of the times, I would be able to persuade them to ask for joint custody because they will realize that there's no point of asking a sole custody. Unless the other parent, if he or she really doesn't care, if they have some sort of drug or drinking or gambling issue, they really cannot form any good decisions for the children on schooling, religion, and medical. Okay, but normally, in a normal family situation, I think joint custody should be the primary consideration. Okay, so I prepared 3 examples here just to illustrate custodies. They are just examples. There are millions of cases on custodies. You don't have to remember these particular ones. In PNP, this is a decision by Judge Bruno Chan. He was one of the most experienced judge in family law, and I think he is now in the CFI or he has retired. Okay, he's no longer sitting at the family court. Now, in this case, it was said by Judge Chan that there does not have to be perfect harmony or total agreement between parents before the court can consider making an order for joint custody. Even during the best of time in a happy marriage, parents do not always agree over the welfare of their children. This is common sense, right? Very enlightening, I think, this observation. Because, I mean, if you can agree on 80% of things, then very likely these parents are able to put aside their differences and try to agree on children matters for the interest of their own children. Okay? In ML and YJ, this is a decision by the recorder Rimsky Yun SC, our former Secretary for Justice. It was said in this case that joint custody was not appropriate because there was no reasonable prospect that the parties were able to cooperate with each other. The court is not to grant joint custody solely to encourage the parties to overcome their difficulties or to recognize the continuing parental role of the parties. The paramount interest is always the welfare of the child. Okay? So on one hand, you have a case that says that you don't really have to be 100% in agreement. But on the other hand, if you really can't agree on things, then joint custody is not appropriate. In RWS and KCC is a judgment by Judge Malloy, the only foreign judge currently sitting at family court, who will be retiring soon. In this case, there were some medical issues with one of the children, and the parties could not agree on those medical decisions. The child had some speech problem, he has language problems, and he also has seizures. The disagreements between the parents have left them in deadlock. So it was held in this situation, it is important that the decision-making power is ultimately vested in one parent. So basically, if the child is in a very urgent medical situation or has a long history of medical needs, then you really need to be able to make that decision sharp and prompt, okay, for medical treatment. So in this case, it's sole custody. There is also this thing called split custody. It means when there are 2 or more children in the family, then you split the siblings. This is really not ideal. And it doesn't make sense to me in custody. Custody is about making important decisions. And you can't reasonably say that the father is in the better position to make decision for one child and the mother is in a better position to make decision for the other child. Right? It doesn't make sense. In W&W, the case involved a 9-year-old girl and a 5-year-old boy. Both parties have urged the court to grant the custody of the girl to the mother and the custody of the son to the father. There was a social welfare report, and it revealed that at the time of the daughter's birth, she was placed with the mother's family, but not with the mother or the father. And when the father moved out of the matrimonial home, the mother remained in the matrimonial home and the girl remained with the mother's family. They're in 3 different households. So the mother and the girl were living separately, but they were close enough to each other because the girl was under the family of the mother. The son lived with the father's brother and the brother's wife. The father only moved in with them after he left the matrimonial home when the son was 2 years old. So the 2 children, they have never lived together under the same roof. They did not enjoy the advantage of sisterhood or brotherhood. The girl also has never really lived with either parent. It appears that the son has never lived with the mom. So in the end, the custody of the daughter was granted to the wife with reasonable access to the husband, and the custody of the son was granted to the husband with reasonable access to the wife. This is very exceptional in having a split custody. Okay. The reason why you want to have the siblings together is that you can have some sort of support from a sister and brother. But in this case, they've never spent time together. They were never really in the same household or in the same family. In fact, these 4 persons involved, they all lived separately in this case. But this is very exceptional. The paragraph I've quoted here, I think it's the 2nd or the 3rd paragraph of the case. This is the general principle saying that to split up the children of a family is inherently undesirable from the point of view of their welfare, which was the first and paramount consideration. If reasonably possible, such a thing should be avoided. Any court would be reluctant to bring about such a split. And even where the court was faced with a de facto split, such as in this case, it would always examine all the relevant circumstances very closely before turning such a situation into a de jure by its order. Okay. But because in this case the facts are so exceptional, they all lived separately. Okay? And both parties wanted a split custody. Okay, any question on custody? Okay. I think in normal situations, the right of custody is meaningless in practical sense. Okay? Theoretically, it's really significant because it gives you the right to make significant, important decisions, but in reality, you rarely really engage in these rights. I think in Hong Kong, most parents would exercise this right when they choose the schools for their children. That's about it. And maybe religion, medical is also very rare. Care and control, it is the same case I have cited here, because it's a really good judgment. Care and control refers to the day-to-day care of a child by the parent with whom the child lives. Okay. In Chinese, it is called 照顧及管養權, literally. So for care and control, the decisions to be made by a parent who at any time has care and control are of a more mundane, day-to-day nature decisions of only passing consequence in themselves, but cumulatively of importance in molding the character of the child. They include a host of decisions that arise out of the fact that the parent has physical control of the child and the responsibility of attending to the child's immediate care. They include decisions as to what the child will wear that day, what the child may watch on television, when the child will settle down to homework, and when the child will go to bed. They also include the authority to impose appropriate discipline. So if you have kids, you will know you get to decide what time they get out of bed, what they eat for breakfast, what they wear every day, the time you are allowed for your child on YouTube, on computer games, and on television, what time they should take their bath, what time to do their homework, and what time to go to bed. These all can control. And these rules, disciplines, and routines set by the parents with care and control will shape the child as to their habits, routine, and in the longer run, their characters. Okay, that's clear. You should know the difference between custody and care and control. It's quite simple and straightforward. Traditionally, we would usually have sole care and control. So the child would live with one parent, the parent with care and control, and there will be access with the other parent, the non-care and control parent. So typically, in that traditional model, you might have 1 to 2 days of access. You might have some dinner time during the week. You might have overnight sleep at the other parent's place. These days, we have some modern concepts called shared care or joint care and control. So with joint care or shared care, it means that you will split time between the father and the mother more or less equally, and there is no need to discuss the concept of access. In S and Z, it is a judgment by judgment law. The mother wanted joint custody and joint care and control. The father wanted sole custody with defined access to the mother. So effectively, he wants to have sole care and control. And during the hearing, the parties have agreed that the care of the children should be vested in whichever parent was looking after the children at the time. And that parent will make everyday decision for them. And this reflected the wish of the children to avoid situations where parents had to discuss things, thus avoiding the opportunities for conflict between the parents. And in the end, the father has sole care and control, the sole custody of the 2 boys. But instead of making a traditional sole care and control order with access to the other party, the arrangement was ordered to be that the care of the boys be shared between the parents. think this is the first time that care and control be shared. This expression has arisen in case law by Judge Malloy. So the time is structured such that the boys will live primarily with the father and spend defined time with the mother at weekends and after school, and the school holidays are split equally. They have this framework in place just to ensure that they had certainty and clarity, which was in fact requested by the children, who were separately represented, and they also met the judge through judicial interview. The beauty of a shared care and control, or joint care and control, is that it would do away the imbalance between the sole care and control parent and the access parent. And usually, in a shared care and control order, the time will be split more or less the same, equally between the parents. So in a week, you can have 4-day and 3-day split. But it doesn't have to be like that. It also, this model of shared care also caters for the modern trend to develop into a parental responsibility-oriented scheme instead of a rights-based framework. Okay. It also avoids the situation where there is an emergency, but the child is with the non-care and control parent who cannot make care and control decisions. There is a difference between joint care and control and shared care and control. This is discussed in the case of SKP and YITT. This is yet another decision by Judge Malloy. And in fact, this whole line of authority on joint care and control and shared care is developed by her. She knows it the best. Some of the judges still don't understand it. This case concerns a 3-year-old girl with both working parents. The girl was cared by a foreign domestic helper. The parties have agreed on how to divide up the time of the child between the two households, and the girl has well adjusted to the arrangement. The only thing they cannot agree on is the use of terminology. They have agreed on custody, but they can't agree on care and control. For the father, he wanted shared care. For the mother, she wanted sole care and control with reasonable access or generous access to the father. So in this judgment, Judge Malloy has drawn a distinction between joint and shared care and control. For joint care and control, it denotes a situation where the parties are sharing the day-to-day practicalities of raising a child. It would normally mean that the child is spending significant periods of time with both parents in each of their homes, but not necessarily on a 50-50 basis. But the time shared is likely to be more significant than in a standard custody access type order, and would probably mean that the child is spending at least 35% of his time based with each of his parents. One would expect that both parents are involved in the schooling and the extracurricular activities schedule, and it normally denotes a high level of cooperation between the parents. A high level of cooperation between the parents. So consequently, one would normally expect an order for joint custody and joint care and control to be made by consent, but court intervention to that effect is not precluded. In the language of the social scientist, an order for joint custody and joint care and control would probably be reflective of a cooperative co-parenting scenario. Okay. So joint care and control is when the parents are able to co-parent. So very, very likely you would have when you have joint care and control, you will also have joint custody. Shared care is different. The concept of shared care is an alternative to joint care and control. In each of these cases, which have developed over time, and for a variety of different reasons, it was felt appropriate for the ultimate decision-making power to vest in only one parent, and thus orders were made for sole custody. However, the court was anxious to ensure that the children involved should continue to spend significant amounts of time with both parents in a way that was more reminiscent of a joint care and control order. In order to recognize this and the fact that the non-custodial parent continues to have a great deal of practical control in the child's day-to-day life, the phrase shared care was coined. Again, in social science terms, this is perhaps more reflective of a parallel parenting regime. Parallel regime, where there is a very high level of conflict between the parents, which makes cooperative co-parenting virtually impossible, but where it is in the children's best interest to spend significant periods of time with both parents. It would be normal in a situation like that to set out very clearly how the children's time is to be split between both parents. There is no order for access, per se. So in summary, a joint care and control signifies a very high degree of willingness and potential on co-parenting and cooperation. Shared care is for high conflict parents. It runs on a parallel scheme. And in that case, you would usually have a fixed timetable as to the specifics on children arrangements. But the time will also be shared more or less equally. And in either situations, you won't have an order on access. It's not necessary. Whereas in a joint care and control situation, the order is just that the parties will have joint care and control. Usually, it won't define how the time is to be split, because the parents can figure it out between themselves, and it's more flexible, because they can still talk to each other. Joint and shared care and control are new developments in law. They are loosely used by a lot of lawyers and even high court judges. Okay? And there is no official Chinese translation for it. For both, it is usually called 共同照顧及管養權. But you probably don't know whether it refers to a joint or a shared care order. But it's okay, because labeling is not important. You will figure it out from the way that the order is being drafted. Okay? Are we clear on the difference between joint and shared care? I hope it's not too confusing. And access, very quickly, access is granted to the parent who does not have care and control in a sole care and control situation. So he or she can spend time with the child on visitation or overnight staying. Access in Chinese is officially called tamsi. Okay, and when we say that access is granted to a parent, it seems to be saying that the right of access is with the parent. Okay? But it has been said that access is in fact the right of a child to have contact with his or her parent. Just a little bit of law for you. Access can include reasonable access, 合理探視. the order would usually just say reasonable access be granted to respondent or petitioner, and the parties can arrange between themselves. Of course, reasonable access is granted on the premise that the parties can still communicate to each other for arranging access. But inevitably, there will be some arguments on access. Okay, sometimes you would have, let's say the mother has sole can control and the father has access. Because there's no fixed framework, then the father might out of the blue ask if I can see the child in like half an hour. And the mother will be like, no, I have made arrangement for a birthday party, attending the child's friend's birthday party, so I can't. And then there will be disputes like that from time to time. Defined access, 界定探視，界定. So you would have a fixed time, okay, such as 10 a.m. to 1 p.m. every Saturday, something like that. I didn't include here, but you can have dinner access. Usually dinner access would also be in the form of a defined access. It would be like dinner access from 5:30 to 8 on a Wednesday, on every Wednesday. Something like that. Usually it's defined. Otherwise you would fight. Staying access, 過夜探視. So it allows the non-can control parent to have sleep overnight with the child. Electronic access, it can be telephone. In modern days, it's usually FaceTime or video call access. And sometimes when the child has their own mobile phone, you can also have WhatsApp access. Or it can be through the WhatsApp of the can control parent. Okay, different forms of electronic access as technology develops. Supervised access, 監管探視, is something special. It means the access has to be conducted under the supervision of a social welfare officer. And it's usually in the office of the social welfare department. That happens when there are some serious issues with the parents or when there are difficulties in the parent-child relationship that cannot be easily overcome. So if you remember, I told you about the example of Jonathan and Jaden, where the mother wants to take the children to Australia, and in the end there was a split order. Because the mother had the children physically, on the interim basis, she had interim sole care control. So there was access with the father. But because in our case, the children have been coached and brainwashed by the mother, and the mother doesn't really allow the children to see the parents, the father. She keeps saying that the children doesn't want to see the father and hence does not allow the access to be conducted. So as time passes, as you would expect, that the children, especially the young son, feels really strange towards the father. So in that case, access has been arranged initially for a few times in the office of the social welfare department as supervised by the social welfare officer. It was really difficult, and the child was crying the whole time and screaming and asking to leave. It was really stressful for the father. But the worst thing is that the mother was present in that situation, which is usually not ideal. When you have access with, for instance, a father, the other parent, the mother, really shouldn't be there because the child would have loyalty conflicts. They would have preference between parents. They would usually want to protect one of the parents and hence show unwillingness to spend time with the other parents. Okay, so in that case, the younger son, the elder son Jonathan didn't come at all. He was simply not interested in leaving the hotel room. So the mother was only able to bring the younger son to the office for maybe 3 times only. And there was no meaningful contact between the father and son, except a lot of crying and disappointment and desperation. So now you have a whole combination of orders. You can think about that after the lecture and play around with it. Okay? So that's basically it for these are the basics when you have a trial on custody, care and control. You have the list of orders you can make. You now understand the concept of custody, care and control, and access. You have the so-called welfare checklist from last class, so you know the relevant considerations. And you know the procedure already. So normally in the divorce, these are the things you have to know for fighting, well, not fighting, but asking for the relevant custody or care and control orders. The rest of the lecture is for relocation and worship. They are also very short. It's now 8 o'clock. Do you want to take a break? Okay, I think I can let you go relatively early tonight. So I think we can take a break now for 15 to 20 minutes, and then we have another maybe 45 minutes. And you can go way before 10. Okay? Children is a little bit boring. I appreciate that, and you're tired. It's fine. It's all in the practice. It's all. Well, if you are a parent, you would really get it. But if you're not, then you really show no interest. I was like this when I was a student. Okay, I found it really boring and tedious because you don't see it happen. When you're not a parent, you can't imagine it. Okay, I'm able to do more children cases because I'm doing more and more cases. All right, so let's have a break and come back before 20 past. Okay, we can have a longer break today. Thank you.